The case before the court is the case concerning the GSC. The parties are applicant, the Union of Ambrosia, versus respondent, the Republic of Ravinia. The applicant and the respondent are each allocated 45 minutes to present their pleadings.
Very well, then the session will now begin, and the floor is given to the first speaker of the applicant. Please go ahead. Please proceed.
The first applicant seems to take a little while to get to the podium here and get ready to start. It's over 20 seconds. Now, it's not a problem here. He's the first speaker, the bench is settling in, and he's waiting for a clear signal from the bench that they're ready for him. But this is a good opportunity to comment on the etiquette of getting to the podium. There are different practices on whether the speaker waits at the bar table until called or goes to the podium and waits there. Probably most teams would wait at the bar table until called. But whatever practice is followed, it's really important not to keep the bench waiting. So the speaker should take whatever time is necessary to get to the podium, calmly set up their folder, their timer, but not take so long that they run the risk of irritating the bench. And of course, the speaker must not start speaking until the bench is clearly ready for them.
Madam President, Your Excellencies, may it please this honorable court. My name is Vladislav Levchuk, and I'm honored to appear before you as the agent for the applicant, the Union of Ambrosia, together with my co-agent, Ms. Anastasia Shashkevich, and our agent of counsel, Mr. Vladislav Mikhalchenko. In the next 22 minutes, I will argue that this court has jurisdiction over the submission B, and secondly, that the assertion of criminal jurisdiction, arrest, and prosecution of Ms. Cross in Ravinia are inconsistent with international law. My colleague, Ms. Anastasia Shashkevich, will further assist this court with the remaining submissions C and D in the next 21 minutes. And Your Excellencies, we respectfully reserve 2 minutes for the rebuttal. May it please the court.
This is a classic Jessup introduction. It introduces himself, his co-agent, and his of counsel, and the submissions he'll be addressing. He also makes eye contact with the judges and delivers it in under a minute. This is a typical Jessup introduction that you will see in every level of the competition. This will be expected, and if it's not done, I've seen judges asking, how long will you be speaking, or how much are you reserving for rebuttal or rebuttal?
This is a very small detail, but the first applicant says that his co-agent will address the court on submissions C and D without indicating what they are about. I personally think it would be more helpful to the bench to say just a couple of words on what those submissions are about, the general topic. The applicants are reserving 2 minutes for rebuttal. That's a good general rule. Any longer, the risk is that the rebuttal will lose its punch, too much content, too much detail. Any shorter means the rebuttal would probably be rushed.
Starting first, Your Excellencies, with the question of this court's jurisdiction. On May 2nd, 2024, respondent has prosecuted Ms. Cross by first issuing an arrest warrant based on her alleged complicity in crimes of enforced disappearances. The core matter that the applicant and respondent have brought within the subject matter of the submission B is whether such measures of constraint are lawful under international law. In July 2024, applicant has filed an application before this court invoking Article 21 of the OCDB Charter as the compromissory clause in light of Article 36(1) of this court statute.
So already you can see how the oralist is speeding up a little bit, and overall displays a style that is maybe not typical for a final round, in that he has a very strong flow in his speech. and tends to present in a, let's say, a little bit more engaging manner.
Your Excellencies, it is our submission that this court has jurisdiction upon the compromissory clause, which has two preconditions, material and temporal one. And it is our submission that both of these preconditions applicant claim satisfies because first, the dispute at hand arose out of facts or situations that happened after Article 21 of the Charter entered into force. And secondly, given that the question of persecution of the former Minister of Ambrosia for international crimes of enforced disappearances is not essentially within respondent's domestic jurisdiction.
A very nice introduction by the speaker, both factually and legally, of the first submission. It was over a minute, so it was a bit long. I also would have led with his argument points first, like the court lacks jurisdiction because of point 1 and point 2, as opposed to a factual summary. That being said, in the preliminary rounds of many tournaments, it is typical to ask if the court wants a brief recitation of the facts, so I can understand why the speaker led with the facts.
Counsel, isn't it necessary for the court to decide this case on the merits, for the court to look at facts and situations that occurred prior to entry into force?
So, rather early question from President Donahue. Sometimes this can be a strategy by the judges to see whether they can throw the oralist off their game. Here, it might also be a hint to the agent to cut more to the chase and highlight a little bit more clearly what the exact core of the issue is. And one potential issue here might have been that the oralist did not necessarily quote the exact treaty provisions that he was applying in the beginning.
Madam President, could you clarify a question, please?
Now here, the first applicant is asking the President to clarify her question, and this is perfectly okay. It's often necessary. Judges can ask questions which are really not clear, as we'll see possibly shortly with Judge Nolte. So the Speaker should never be afraid to ask for a clarification. Better that than to risk simply misunderstanding the question and giving an irrelevant or an incorrect answer.
Maybe it was nerves, and obviously it's always better to ask for a clarification than risking not answering the question that the judges actually asked.
Is it necessary in order for the court and the respondent state to decide this case, for that court to look at facts and situations that took place prior to entry into force?
Madam President, our answer is no, because the question within the submission B pertains to the question of whether Ravinia has violated law on immunity and jurisdiction. And to adjudicate upon this, the court does not need to delve into the question of natures of the crimes that Ms. Cross allegedly has committed between 2017 and 2020.
So here, the oralist asked Judge Donahue to clarify her question, but it appears he missed the import of the question. He assumed the question was whether the ICJ had to delve into the merits on this issue. But if you listen carefully, she asks whether the court in Ravinia have to address the merits to determine the issue of immunity. Now that's an important nuance that was missed here, because in most cases the initial question of immunity would be before the state court as opposed to the ICJ. This underscores the importance of listening to the question as opposed to answering with something that is in your argument outline.
We would like Your Excellencies to refer you to paragraph 12 of the Statement of Facts.
In terms of strategy, this might be a bit tricky to directly go straight for the facts, when in fact Judge Donahue asked a question about the law, and quoting the exact treaty provision that applicant is applying here and interpreting might have helped the oralist in this specific setting a little bit better.
Where Article 21 of the OCDB Charter is contained. And the wording of this article says that the member states do not recognize the court's jurisdiction over disputes arising out of facts or situations occurring prior to the entry into force of this article.
So finally now the agent is actually answering President Donahue's very first question, relating to the issue of temporal jurisdiction and facts and situations prior to the entry of force of the clause that actually confers jurisdiction to the ICJ in the present case.
And according to paragraph 12 of the facts, Article 21 entered into force on March 17, 2021. So, Your Excellencies, for this court to determine whether the ICJ has jurisdiction, the court needs to analyze from which situations or facts the dispute has arose. Respondent may indeed rely on the cases of certain properties where the court has applied the so-called real cause test. Namely, it defined those facts or situations which led for the dispute to emerge. However, we submit that this case is irrelevant for the purpose of this article because the wording of compromissory clause in Article 21 of the OCDB Charter and European Convention for Peaceful Settlement of Disputes are different. In the latter, in the European Convention, which was used as the basis for certain properties, jurisdiction of the court, there was the wording relating to facts or situations. And according to the ordinary meaning that this court should analyze under Article 31.1, the word regarding to has the broader scope. Your Excellency?
This is another small detail, but the first applicant here refers to Article 31.1, but he doesn't explain what treaty he's referring to. In the context is clearly the Vienna Convention on the Law of Treaties, but it would be better to make that clear, especially the first time that the treaty is referred to.
So here the agent actually digs much deeper than before and distinguishing the present treaty from other instruments. What might have gotten lost a little bit is what the actual test is that the applicant wants this court to apply.
I'm not but does your interpretation of the wording not ignore the object and purpose of the real cause component of in the jurisprudence?
Your Excellency, in Nolte, we submit that it does not conflict with the object and purpose of the real cause, because if the parties intended to include such wording that the court would have jurisdiction, they would adopt the wording in connection to, relating to, or with regard to, so that the court would have jurisdiction over the broader scope of matters in terms of the temporal. But they decided to adopt the wording arising out. And according to the Black's Law Dictionary, the wording arising out means originating from, having its origin in.
Here, Judge Nolte asks whether the applicant's interpretation ignores the object and purpose of the real cause of the dispute based on the jurisprudence. Again, this question underscores the importance of listening to the question. Judge Nolte is asking whether the applicant's interpretation is consistent with the jurisprudence, so I would have expected an answer to involve some type of court case. Instead, the applicant reiterates his plain language interpretation and the rationale for it.
So at this exact point, you can see quite clearly where the part where the agent answers Judge Nolte's question ends, and where he returns to his already prepared speech, which is fair overall, but it might be more elegant to cover up these differences in between answering a question and actually following your prepared roadmap, because that way it gives much more of an impression of interacting with the bench and having a sort of discussion about the issues involved.
And Your Excellencies, as can be seen from paragraph 62 and 63 of the facts, where the president of both states communicated their disagreement on the points of law and facts, the reason why this dispute has emerged and its origin is found exactly in the arrest warrant issued by the respondent and its subsequent enforcement.
Now, pay close attention to the oralist's hand in the way that he actually sort of allows Judge Nolte to ask a question. Maybe the bench didn't see it from their point of view, but this can be a little bit tricky to pull off in terms of hand gestures. In this particular scenario, though, the agent might have needed it because the way he presents his speech does not involve as many pauses. He's very fluent in his speaking, and thus he sort of needs these additional gestures to indicate to the bench that he's willing to receive a question.
But that cannot be the decisive criterion for the interpretation of the jurisdictional clause, because they couldn't think of this particular case. Did the parties want a particularly restricted interpretation or provision establishing jurisdiction by using these only very slightly different words?
Being responsive is not just about answering the question. Here you have to watch the judge's body language carefully. Judge Nolte is clearly not buying the applicant's argument that the phrase arising out of is distinct from the phrase relating to or regarding to. Thus, it is imperative that the speaker, with his answer, address this core concern.
Honorable Judge Nolte, unfortunately, the preparatory works of the OCDB Charter do not give us the reference to the reason why they have incorporated such wording. We can see from the paragraph 11 of the Statement of Facts that the reason why the Article 21 was postponed in 5 years was to ensure that the disputes that were in consideration between the parties before 2021 were not brought ultimately for the court's jurisdiction. And exactly this case, Your Excellency, pertains allegedly to the commission of crimes, which happened between 2017 and 2020. So we can reasonably infer that it was one of the reasons why such language was adopted.
This is a great example of a segue into the first applicant's alternative submission. He answers Judge Nolte's question, and without missing a beat, he moves straight on to his next point by saying, but even if, and so on. So a very good example of a smooth segue.
So I thought the speaker did a couple of things well here. First, he's always looking at the judges while the question is being asked. Many times I will see an oralist look to their notes in an attempt to respond to the question. But in keeping his eyes trained on the judges, the speaker looks like he's trying to be responsive to the court. I also like that the speaker went to the drafting history to answer this question. The question was, how do we know that the parties had a particularly restrictive approach in mind? So his tack to go to the drafting history is a sound one. Here I would have made this a little stronger by noting it was clearly meant to be restrictive, as it was designed to account for then existing disputes. And furthermore, the type of clause used was the Belgian double restrictive formula, which is considered to be the most restrictive one, and then maybe perhaps a case that stands for that proposition regarding the double restrictive formula.
In terms of presentation, now the agent has definitely sped up a little bit more. And it's not just the speed that has changed compared to the very beginning, but also pay close attention to the length of his sentences, because he tends to build them longer and longer, connecting them with many ands, and that makes it a bit harder for the auditorium, for the bench, to actually found the trajectory in his speech.
But even if the court upheld that there is no difference in terms of arising out and relating to, as used in certain properties, we still submit that the certain properties case is relevant on the factual circumstances. In the paragraph 48 of the certain properties, the court indeed stated that for the real cause to be established, there has to be an inextricable linkage between the facts and situations and actually the reason why the dispute emerged. However, in that particular case, the real cause and inextricable linkage was to be found in the legislative origin of the confiscation of the painting of Liechtenstein prince. Here, Your Excellencies, we would like to emphasize that there is no legislative origin, and 2007 legislation is not the reason why the dispute emerged, as the respondent contended on the page 4 of their written submissions.
So what I like what the speaker did here is that he answered a question and then pivoted to a legal authority that the respondent was going to rely on and then distinguished it. Maybe it could have been done a little more succinctly, but I thought it was done effectively within the confines of his argument.
Always a tricky thing for the applicant to refer to the respondent's written submissions, because you never know what the respondent actually will bring forward. It might be more elegant here to introduce any such arguments in a manner of respondent may argue that.
Your Excellency.
When exactly the dispute emerged?
And again, the question from the bench more or less relates back to Judge Donohue's very initial question several minutes ago. This is tricky for the oralist because now he must probably have felt like he was led around in a circle once and he is still sort of stuck at the very beginning of his argument, even though he mentioned many authorities, compared the instrument before the court today to other instruments and respective jurisprudence on tests for the jurisdiction, the temporal jurisdiction to apply.
Your Excellency, according to paragraph 62-63 of the facts, it is our submission that is 6 May 2024, when President of the Respondent answered to the disagreement voiced by the President Derry. And Your Excellency, exactly this dispute emerged after the critical date of entry into force of Article 21, namely in 2024, 3 years after, and therefore the court has temporal jurisdiction to adjudicate on the submission B.
This is a nice, direct answer to a straightforward question. Sometimes a question simply asks for facts or asks for where in the record a certain fact is located. Here the speaker cited to the record correctly, and more importantly, he closed the loop on his argument by tying it to why the court lacks jurisdiction.
Turning then to the question of subject matter jurisdiction, we would like to submit that the persecution of the former Minister of Ambrosia is not essentially within respondent's domestic jurisdiction.
The speaker does a nice job turning to the second part of his first submission. So far, I think he's doing a decent job of time management because he's about 8 minutes into his argument. He also transitioned after answering a question, which is a classic technique.
And, Your Excellency, the major issue here, to clarify, is the wording of Article 21b2, which can be seen in paragraph 12 of the Statement of Facts. According to this provision, the court does not have jurisdiction over disputes relating to judicial proceedings on matters which, in accordance with international law, are essentially within a member state's domestic jurisdiction.
And now you can maybe realize how the oralist slowed down again. So in the beginning of his second submission, he's getting back to a slower pace that might allow the bench to follow his reasoning a little bit better. And yet, also pay close attention to his hand and his hand gestures, because still he tends to rely a lot on his body language in terms of structuring his speech, instead of mostly using his voice, stressing certain words, and pausing at strategically well thought out points.
So for this court to determine which matters are essentially or not within domestic jurisdiction, the court should find the answer in international law. And in the Interhandel case on the page 22, Switzerland versus the US, the ICJ established that the court should reach the provisional conclusion that the matter is governed by international law to decide that it does not lie within essential domestic jurisdiction of the state.
Judge Nolte is about to ask a long question, which he doesn't think is fully understood by the first applicant. This is a good illustration of the difficulties that long questions from the bench can pose for speakers. It can be hard to work out what the actual question is. I think the response that the first applicant gives is very reasonable. Judge Nolte, though, then repeats the question in a slightly different form, basically asking, aren't all criminal matters essentially domestic? And here the speaker makes a good submission, but he doesn't really answer the question directly. So see what you think.
Now, the clause with regard to the a matter being essentially in the jurisdiction, domestic jurisdiction of a state is an old formulation. And for years and decades, lawyers agreed that this space shrank because international law expanded so much. Now, these states concluded a treaty in 2016 or later using this clause. I would imagine they wouldn't use a clause which they would know would have essentially no content. So I would assume that for such a clause to make sense, it means it has to be given room. Would it not be possible to argue that criminal cases are typically in a national, done in a national forum, whereas other kinds of cases, international trade or something, that are more obviously international, but to prosecute somebody for criminal prosecution, criminal law is more national. Wouldn't that be an argument?
Now, this is what every oralist dreads, the long question that eats into your time. The question lasted for almost a minute and a half. Now, it is easy to lose patience as time is running out, but the speaker is very patient with the question, keeping his eyes trained on the judges at all times. The good news about these long questions is that you will have sufficient time to formulate a good response.
Honorable Judge Nolte, we agree that generally the law enforcement and domestic prosecution are the matters of essential domestic jurisdiction. And we would agree that the matter would be essential for the respondent if Ms. Cross was, for example, driving a car, being in her private capacity, and was, for example, engaged in the car accident on the territory of the respondent.
So very general, very doctrinal, law-oriented question, and the oralist tries to answer it rather narrowly, giving factual examples to strengthen his reasoning. Let's see if Judge Nolte accepts this.
But the central question here of the judicial proceedings before Ravinian Criminal Court is whether the former Minister of Ambrosia enjoys functional immunity for the acts that were conducted under the governmental ILSA program. And here, there is an invocation of the international element of functional immunity.
I think you may not have understood what I meant by my question. Of course, there's an international legal question with respect to jurisdictional immunity involved. But my question is whether the kind of case that was considered to be essentially under domestic jurisdiction are criminal cases as such. And even if, like in many, many cases, there's some international legal aspect to it, we should not be too complicated, perhaps.
And there we are. Judge Nolte does not like the answer and rather repeats his question, more or less continuing the cycle that we already saw in the first submission of the applicant, where judges tend to repeat the questions, trying to get the oralist to change his strategy and potentially also style in answering.
So when the judge says, "I don't believe you understood my question," you really have to figure out the true import of the question. Here, Judge Nolte is saying that criminal cases as such are judicial proceedings essentially within a court's domestic jurisdiction. The speaker, however, tries to make a distinction as to the type of criminal case that was being considered. But as Judge Nolte points out, sometimes criminal cases or other cases have an international component to it.
Honorable Judge Nolte, yes, and we understand the reasonableness behind this question, not to make the provisions of the OCDB Charter meaningless. However, the ICJ...
Now, seeing the judge nod to one of your answers is probably one of the most satisfying feelings, especially in a final round, and especially in this setting where it might have taken the oralist some turns to get where the judges wanted him to be. And now finally he managed to reconnect better with Judge Nolte's question.
J in the paragraph 25 of its provisional measures order on Tehran hostages case explicitly stated that the detention of internationally protected person in this respect, former Minister Cross, that enjoys functional immunity under custom is the matter which stripes the question of being essentially domestic for the respondent. And therefore, Your Excellency, the court does not have, the court has jurisdiction over the submission B on the subject matter precondition.
So the Speaker does well to cite to law, which is what I would try to teach my students when you're getting a question like this. However, I think he missed the mark here with his use of the Tehran hostages case. He's using it for the proposition that the detention of someone with protected status is never a domestic issue. But in that case, the MB officials were clearly protected at the time. Here, however, Mr. Cross is now a private citizen and no longer enjoys that protective status as a current government official. In the end, I'm not sure he addressed the true heart of Judge Nolte's question, which was whether criminal cases as such are judicial proceedings that are essentially within the domestic jurisdiction of the state.
Turning then to the submission B, Your Excellencies, if you do not have any further questions.
So here is another seamless pivot to the next submission. Even though the Speaker says to the bench, if you don't have any further questions, his whole tone and pace ensure that there is no room for further questions from the bench. So he can just move on straight to his next submission without any further delay from the bench.
We submit that Ravinia violated legal rules on jurisdiction and immunity by prosecuting former Minister Cross. And we have two main arguments in this respect. First, that universal jurisdiction is subsidiary and the respondent first must have extradited Ms. Cross to Ambrosia, given the pending extradition request. And secondly, that the immunity under customary international law prohibits Ravinia to prosecute Ms. Cross domestically.
The Speaker does a nice job of road mapping his second submission after concluding his first submission. It is important to reorient the listeners again by providing a very brief outline and roadmap of the second submission, which was done nicely here.
Starting first with the question of universal jurisdiction, Your Excellencies. We agree and we understand that respondent may refer to Article 11, Paragraph 1 of the Convention on Enforced Disappearances in force between parties, as per Paragraph 68 of the Statement of Facts. And indeed, Article 11, Paragraph 1 establishes an obligation to prosecute the crimes of enforced disappearances. However, with one very important caveat, and I would like to quote, if it does not extradite him or her in accordance with its international obligations. Your Excellencies, President Donahue.
Please explain how you interpret that provision in light of the court's decision in the Belgium versus Senegal case in 2012. Thank you.
Very pointed question by President Donahue. Maybe also bearing in mind her experience with the oralist so far, she now really wants to push him to very specific details and very specific points.
President Donahue, we are aware that in paragraph 95 of Belgium versus Senegal, the ICJ ruled that the obligation to prosecute within the Convention Against Torture is primary and obligation to extradite is discretionary.
This is an excellent answer to the President's question, which is about how the applicant's submission relates to the court's decision in Belgium and Senegal. So the Speaker gives a clear and direct answer and then goes on to really skillfully distinguish that decision from the present case. So this is a really good example of a responsive answer.
However, the peculiarity of that particular case was that Belgium has requested the extradition based on the Convention Against Torture. So the court proclaimed that the obligation to prosecute prevails over obligation to extradite within the framework of the single instrument. In this respect, we can see from clarification number 5 that there is a bilateral extradition treaty between applicant and respondent. And according to Article 13, Paragraph 2 of the ICPPD, enforced disappearances should be considered an extraditable offense if the extradition treaty was adopted before convention entered into force.
Responding to the question of how his case is interpreted in light of the Belgium versus Senegal case, the Speaker does a great job distinguishing it. He knows the key distinction from that case is that unlike in that case, there is a bilateral extradition treaty here that would excuse the duty to prosecute. He starts off well, but I would have led with the fact that the key distinction from that case was that there was no extradition treaty, whereas here there is, and that is the reason for the different result. It could have been delivered a little bit more succinctly, but still a really good answer.
And we have actually requested extradition of Ms. Cross, but according to the last sentence of clarification number 5, respondent has purely ignored and did not respond to this extradition request. Your Excellencies, the common sense approach that the states follow by deciding on extradition is so that universal jurisdiction can be applied as the measure of last resort to combat impunity for international crimes, but still given the room for the states where the crime has been committed due to the accessibility of evidence.
What I particularly like here is that the Speaker appeals to common sense. Many times when judges are trying to make decisions, they are trying to make a reasonable one. Here, he couches his arguments as a common sense approach, which is very appealing to most judges.
And Your Excellencies, here we have requested extradition, and if respondent refused this extradition on the relevant grounds, we would agree that obligation to prosecute should be fulfilled. On the contrary, they ignored our extradition request, and moreover, according to paragraph 61 of the facts, they proceeded with the prosecution of Ms. Cross.
If they would, sorry, go ahead. So if they would have answered, we will not accede to your extradition request because we think you will probably pardon the person, you would have been satisfied.
Honorable Judge Nolte, we are aware of such potential argument from the respondent that they referred to in their memorials. However, first, it is really important to emphasize that for the legitimate grounds to refuse extradition, this has to be the provision envisaged in the treaty. And neither Model UN Extradition Treaty nor any other regional instruments, such as European Convention on Extradition or Inter-American Convention on Extradition, do not prescribe the neither mandatory nor additional grounds as the so-called unwillingness or inability to prosecute. Moreover, the contention of the respondent is also erroneous in terms of fact. Your Excellencies, indeed, in the paragraph 57, we can see that President Derey stated that Ms. Cross, and I quote, was a loyal servant of the people, and that the ILSA program that she governed administered saved so many lives.
This is a dangerous strategy because what the agent does here is not so much answer Judge Nolte's question, but much rather reply to a potential argument by respondent. And in this specific setting, pointing out that they are erroneous seems to be a kind of backhanded strategy because ultimately one doesn't know if this is actually the exact argument that respondent would like to make.
However, this was said purely in terms of her role as the minister, because according to the statement of facts, Your Excellency, paragraph 10, the drug trafficking and, Your Excellency, illicit fishing as the problem why the OCDP charter, why the OCDP has been grounded. It is really vital for the national security problem for the Union of Ambrosia. And ILSA program was exactly incorporated to combat these issues. And it was
We again see a situation where the agent starts to pile sentences upon sentences, connecting them with and this is where the bench cuts in.
Counsel, mindful of your time, Judge Robledo Gomez has a question, and then after you address his question, I'd like to encourage you to move on to the final topic that you wanted to address, please. Please go ahead.
Does your government be willing, or would your government be willing to give guarantees to the respondent in order not to grant any kind of a pardon or clemency as a way of securing the extradition?
Your Excellency, unfortunately, I cannot answer on behalf of our prosecutor agencies. However, if respondent can request the assurances that there would be no pardoning, we would do so. And it was, for example, in the recent case of Italian Supreme Court in 2024, which have satisfied the extradition request regarding the Ukrainian national, based on the assurances that Ukraine gave that they would not violate the rights of this person during the wartime. What was the main concern of the Italian Supreme Court to grant this extradition?
So here the speaker answers a hypothetical question correctly regarding the giving guarantees to obtain extradition. He correctly says he's not sure what the prosecuting agents would do. Here, however, I might alter it slightly, saying that I don't have authority from my government to make that guarantee, but we would be open to it if it would expedite extradition. Then I'd turn it back on the respondent and point out that it's the respondent who are the ones who have not responded to the request, so we have no way of knowing how to address their concerns. He does, however, nicely point to authority which stands for the proposition that extradition has occurred when concerns are addressed.
Then again, the follow-up with the state practice that the agent brought forward here, I didn't actually understand in terms of strategy. First of all, the example gets a bit lost because the agent does not refer to the actual facts of the case he's quoting. And second, if his answer is no, he will not make any concessions or promises on behalf of his government, that's where his answer could have stopped.
As per request of President Donahue, we would like to move to our final argument on immunity.
Here, the Speaker is moving to his last submission, that's on functional immunity, with 3 minutes to go. It's leaving it pretty late, but he does seem to cover what he wants to cover in that time.
Where we submit that Ravinia is barred to prosecute Ms. Cross according to the customary rule on functional immunity that is applicable for the acts during the office and in the official capacity. The core question here before this honorable court is whether acts of Ms. Cross are to be regarded as an official capacity. And the respondent may claim that these acts are committed ultra vires, namely in the access of instructions of authority. We recognize that in paragraph 8 of the Statement of Facts, President Dere instructed Ms. Cross to implement ILSA program and to do all lawful measures. However, Your Excellency, the nature of crimes is not at the stake here, because the question of immunity, as recognized in the jurisdictional immunities and arrest warrant, is the procedural matter and not the substantive one. And the court has relied on the ILC draft articles on responsibility of states for international wrongful acts. And as subsidiary means for determination of the rules of law, we invite to consider the draft Article 7, where the ILC stated that even if the acts may be criminal, they are still committed in the color of authority. And Ms. Cross...
Counsel, can I ask you to move to the question of waiver, please?
The Speaker tries to make an argument, but is asked to move to a different part of his argument. Sometimes this can be a bit disconcerting because it might give the impression that the judges don't care for what I have to say. What I think he did particularly well here is he showed his cool and proceeded to address the court's concerns. The Speaker should always be responsive to the judge's concerns, and here she wants to hear about the waiver. He does a nice job of adapting and addressing the court's concerns.
Certainly, President Donahue. The potential argument of the respondent is that there is an implicit waiver of immunity under the framework of the Convention on Enforced Disappearances. However, Your Excellency, we submit that ICPPD is silent on the question of immunities. And Your Excellency, on the contrary, for example, Article 4 of the Genocide Convention explicitly waives immunity for individuals in the face of the genocide. We acknowledge that draft Article 10 of the Convention had in its provision the waiver of immunity, saying that, and I quote, any pardon, immunity, or any other exemptions are unlawful under ICPPD. But ultimately, this provision was excluded and is no longer present in the provisions of the ICPPD.
The Speaker gives a nice summation of why there is no implicit waiver. He points to another convention where the waiver is explicit, and then he points out correctly that it was in the draft section version, but it was dropped. I thought this was a really good answer. Maybe it could have been delivered stronger by saying that waivers generally should be explicit and then use the Genocide Convention example. Then he could have explained that the reason the waiver was taken out of the ICPPED is because states wanted the ability to give immunity to lower level officials as an incentive for them to turn and give up higher level officials.
And as this honorable court stated in arrest warrant in paragraph 50, even if there is an obligation to prosecute or extradite under the convention, in that respect, the Convention Against Torture, it does not render the customary international law granting functional immunity inapplicable. Your Excellencies, we acknowledge that the goal of the ICPPD is to combat impunity for enforced disappearances. But as per the ICJ in the arrest warrant paragraph 60, immunity does not mean impunity, because the applicant is willing and able to prosecute Ms. Cross, and that is why we have requested her extradition. Your Excellencies, if you do not have any further question in respect of the immunities, we would like to conclude our submission and to ask this court to rule in favor of the applicant, that respondent violated rules on immunity and jurisdiction by prosecuting Ms. Cross domestically. Thank you, and may it please the court.
So, first speaker of the applicant, what have we seen? A very skilled oralist and an oralist whose forte is much more a very fluid way of speaking, with the tendency to rather build longer sentences, not necessarily giving the bench lots of room for questions unless they interrupt him. And this is what this particular bench did quite frequently. And whenever the agent started to gain lots of momentum, that's when the bench cut him off and brought him back from his speech, mostly with oftentimes very narrow, very pointed questions, in some way trying to bring him to get a little bit sooner, a little bit faster to the core issues that were at stake here. Also, the more or less slow and steady pacing that one might have gotten used to during final rounds is not necessarily where this particular speaker excels. So you can see throughout his pleading how he at times struggles a bit to maintain a slower pacing, because this is technically not who he is as an oralist. He excels much better in a more engaging way of presentation and a more, let's say, communicative style.